Due Process, winner of 21 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2012 Mid-Atlantic Emmys for Outstanding Interview Special and Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
Saying this guy did me wrong, that guy, that's not going to solve anything.
But
that's
the whole
not
system did you wrong. Surely you're angry.
But the system also righted the wrong that they did.
David Shepard knows just how wrong it can go when the eyewitness, in his case, the victim, is absolutely sure and absolutely wrong. For Shepard, it meant 12 years in state prison before DNA finally cleared him. Yet another reason for new state Supreme Court rules to make tragic mistakes at trial less likely. That's up next on Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy.
We've seen it on 100 Law and Orders. Police come up with an eyewitness to a crime. The prosecutor comes one step closer to a win, and it's all pretty simple on TV. In real life, it is anything but. So last year, the state Supreme Court gave new official recognition to the fallibility of witness IDs. And now the court's gone further with new rules designed to minimize the risk of wrongful conviction. I'm Raymond Brown.
And I'm Sandra King, and wrongful conviction is a story we've been telling since the start of Due Process. A story of tragic mistakes at trial, of precious years lost to prison, because the wrong man was convicted on eyewitness testimony. So if you're a regular viewer, you might remember these men.
I think they wanted somebody, and they found somebody, and that's the bottom line.
David Shepard was our first. He'd been a 19-year-old father, went to work every day, had never been in any trouble until a white woman who'd been carjacked and raped by two black men identified him in an impromptu lineup as one of her attackers.
I didn't have an alibi or a strong enough alibi for him, so okay, we got somebody. We need somebody, we got somebody.
It took 12 years of struggle insisting he was innocent before a DNA test denied to him for years finally proved that the victim had been wrong.
She finds the one that's the closest to the picture she has in her mind. Well, there are two problems here. One is the picture may be quite inaccurate. And the other is, even if it's a fairly accurate picture, to say that man looks as much like the rapist or more like the rapist than anyone else on the stage, it's not to say he is the rapist.
Matt Cromedy, too, was convicted almost entirely on the testimony of his victim, a white Rutgers student raped in her apartment, who spotted Cromedy on the street and told police, that's him. But you were innocent.
Yeah, convicted of something I ain't doing. They ain't had no proof or nothing.
After 6 years in state prison, a DNA test finally showed that she, too, had been wrong.
Cross-racial identification. So there's lots of evidence that when we look at someone of another race, the first thing we notice is their race. And then we kind of stop looking. So we don't have a clear recollection of what he looked like other than he was an Asian man or he was a black man. And therefore, juries believe, because they haven't read these studies, that it is the most reliable piece of information, when in fact it is one of the least reliable pieces of information.
And race was a player yet again in the case of Clarence Moore. Again, a black defendant and a white rape victim. A prosecution that made race an issue, a motivation, at trial. until the Princeton-based Centurion Ministries won his freedom after 15 years.
It's not so much whether you're innocent or guilty, it's like who got the best game, who got the best plan.
You didn't have the best
And I didn't
game.
have it.
But it isn't only cross-racial, it's not just rape cases, and it's not just the victim who can point the finger of guilt at the wrong man and be absolutely, tragically wrong.
I got charged with a murder charge. That's when I said, wow, you know, maybe the system doesn't work the way I think it does.
For Kevin Rojas, it was the victim's friends who made the mistaken ID. Distraught after seeing their friend murdered in a New York street fight, they remembered the killer's orange jacket. When a Union City High School kid in an orange jacket was picked up by police, the friends ID'd him.
He had been mistakenly identified because of the color of his jacket. And
The orange jacket.
the orange jacket. And to my dismay, as I continued following the newspaper accounts, he was convicted.
And served 4 years until a mother and daughter team, convinced of his innocence, managed to mount a post-conviction appeal that won Rojas his freedom through a long, painstaking review of the evidence and without DNA.
Thanks to the Lord and Priscilla Chenoweth and Leslie Reisinger and a team of other lawyers, I've got my life back.
But what may be the most tragic of all is the case of Troy Davis. For him, there will be no happy ending. Although 7 of 9 eyewitnesses recanted their testimony, said they'd been mistaken or induced, coerced to lie, he was executed by the state of Georgia, all appeals exhausted and denied.
Witnesses recanting is a difficult thing because it's that old cross-examination technique. Were you lying then or are you lying now? I mean, when they change stories, you know, I mean, which one was the truth? But still, in the Troy Davis case, I think a tremendous injustice was done. I think they should have opened that case up again.
And Professor Thomas is not alone in that epiphany. We all now know about exonerations due to DNA, but we may not know that most of those wrongful convictions were based on the testimony of mistaken, unreliable, or untruthful eyewitnesses.
But will the new Supreme Court rules really mean better justice? We'll put that to our guests, who approach the question from very different perspectives. Professor Stephen Penrod, a lawyer and psychologist from John Jay College of Criminal Justice and an expert on the eyewitness reliability question. Anthony Guarino, a former assistant Essex County prosecutor who for 20 years sat on the bench in Newark Municipal Court. And Gene Barrett, a national figure in the defense of capital murder defendants, appointed learned counsel by 4 federal districts in more than 25 potential death cases. Welcome to all of you. Thank you. Gene, the case we're talking about, Henderson, was a considerable undertaking. The Supreme Court appointed a special master who then heard evidence from experts, participation by the Attorney General's office, several defense-oriented organizations, and then the Supreme Court issued an opinion which sought to address the issue of 20 years of learning in the science, as well as new procedures for reliability. At the end of the day, does all that make it less likely, in your view, that when some person says he's the guy who did it, that there's less likely that that kind of eyewitness identification will result in wrongful convictions?
I think so. I think as a result of the new rules, the almost mandatory court review of identifications, although not quite mandatory, pretrial review, that that will weed some things out. It will provide more information to defense lawyers so that they can more adequately deal with identification witnesses. But more importantly, I think that the instructions that the court is asking be given at the close of the case to the jury goes a long way toward trying to communicate to the jury the dangers of this kind of testimony.
What's the heart of that instruction? I mean, what basically are they going to be telling jurors?
They're going to be telling jurors that eyewitness identifications are inherently suspect and that there is plenty of scientific evidence to show that often eyewitnesses are very, very wrong about when they make an identification.
Which brings me, Steve, to you. What is the science? What is this that's been going on for 20 years that we've now learned that brought the court to this position?
Well, it's more like 35 years of scientific research looking at the factors that produce mistaken identifications. Primarily experimental research, virtually all of it conducted by research psychologists.
Which shows?
Well, shows, I could do a long litany, 25 or 30, I'd say, modest to large bodies of research around topics concerning features of the witness, characteristics of the perpetrator, characteristics of the crime, aspects of what happens between the time of the crime itself and the subsequent identification, and particularly a large body of research looking at the techniques that are used to produce identifications from witnesses, the things that are primarily under the control of and administered by the police. All of those contribute to varying degrees to problems of mistaken identification.
Steve, let me ask you if I've oversimplified this, that part of it is a finding that, contrary to what many of us might think, the mind is not a tape recorder that can play back at will what we've seen in the past, and that maybe certainty isn't a guarantee of accuracy?
Both of those are accurate characterizations, yes.
Anthony, what do you think about Henderson and about the Supreme Court's effort in this respect?
I would say this. We have the finest system in the world, our jury system. It's made of composite of individuals from various backgrounds, educational, gender, race, economic, IQ, and yet the beneficial synergist effect of them coming together, I think, has a positive result, which makes them amazingly accurate. Does that mean that it's perfect? No. Is there room for improvement? Yes. But I have some issues with some of the charges and the language they use. For instance, when they say in two different areas, research has shown, or relying on some of the research that has been done, I will instruct you. I think that is so doctrinaire when people hear a judge, the objective person, not the combatants, not the adversaries, the prosecutor or defense counsel, saying those words, it has such a dramatic effect. I think they're now looking to find ways to undermine the credibility of that witness.
But if Stephen has accurately summarized 35 years of probably common assumptions by most of us about how memory works, how can it be antithetical to justice for the court to say to people, really be aware that the mind doesn't work quite the way you thought it did, listen to the testimony and make your own conclusion?
Well, one area the charge says, you must critically analyze. I think the words would be better, you must intensely or carefully analyze. When you say critically, you're thinking critical, you're thinking negative, you're thinking pejorative. It's almost like you're looking for a way, again, to undermine the reliability, the truthfulness, and the credibility of that witness.
So I wonder, Gene, if you would agree with some critics from the other side who say this isn't strong enough, doesn't go far enough, that in fact when the charge is told to be tailored to the case rather than just saying there's 35 years of science here that says no eyewitness should be taken at face value. What's actually going to happen in court? Raymond asked you at the start whether it was going to be helpful. You said yes. Are you confident that every judge will even go as far as the court has instructed?
No. And there is a lot that's left up to the individual judges here. For instance, when the judges are giving instructions, they can select what variables they want to charge the jury on that they think are important to the case. I think that that's an area that's going to be open to a lot of appellate litigation.
As opposed to just looking at what Steve tells us is the science.
Right, not the whole science. For instance, if an individual witness had made a comparative selection, the judge could instruct on the dangers of that kind of selection. But if they didn't actually speak to someone else about it, they wouldn't be necessarily instructed on that aspect of it. And you know, with regard to these charges, the judge has so much flexibility in terms of emphasis as to what the court wants to do. But when Anthony was talking before about the weighted language, he's obviously not sat as a defense lawyer at counsel table and listened to the kinds of language that is weighted in the criminal statutes themselves, which put the defense in a less favorable position. So it really depends on the emphasis and how the judge delivers that charge. Yeah.
Stephen, let me come back to one of the dominant myths of the justice system, which is that cross-examination is the great engine in the search for truth. I mean, that's a phrase that we've all heard thousands of times. But one of the interesting things here is that question about certainty, that a witness who may be seeing a lineup that isn't really fair, or may have police officers unintentionally reassure them that they've made the right ID, may seem and really believe they've got the right guy. But there are other things that can be pointed to. That ties into some of the psychological learning and research that's been done in the last few years, doesn't it?
It's clear that jurors are impressed with witness confidence as an indication of whether the witness has made a correct identification. And indeed, I'd say the research indicates that confidence, witness confidence, pretty much trumps everything else, so that a very confident witness who's made an identification, even in the face of a set of adverse circumstances, is very impressive to the jury.
What do we know about, what do we now know psychologically about the relationship between confidence and accuracy?
It's moderately complicated. I would say, in general, confidence is modestly correlated with accuracy. Witnesses tend to be overconfident about their identifications. That is, the accuracy rates don't reach the same level of confidence that witnesses express. In addition, there are problems of feedback to witnesses that occur following identification. So,
what do you mean by that, for example?
If witnesses are given some sort of affirmation, confirmation that they have made something like a correct identification, can inflate their confidence beyond what's appropriate for the accuracy of that identification.
Which brings us to our friend, Dean John Farmer, who in full disclosure is an executive producer of this program, but who was the Attorney General of New Jersey and who made rules that, again, were really somewhat revolutionary for the country. And one of the things was that you can't have a lineup, for instance, in which you have an investigator who is part of the case and knows who is the suspect be the one who runs that lineup. So did you find, Anthony, that what we had 12 years ago from John Farmer made things more fair in terms of the investigative process? And wouldn't you, as somebody who was in a position for 20 years of deciding cases and being the judge of whether justice is or is not served, wouldn't you be pleased to have those rules and these new rules from the court?
Absolutely. I mean, we've come a long way and we've gone further. And I say, overall, it's a phenomenal thing. I think that, I'm proud to be a member of the New Jersey State Bar because we're on the cutting edge in so many ways in our state of New Jersey with these type of things, especially in the criminal law aspects. But here again, I think what Mr. Brown and Ray had said, that, except for foul play and suggestive things, I think that, good cross-examination is the answer. Good, diligent cross-examination by thoroughly prepared counsel their experience.
But you wouldn't have the charge that the court has now ordered every judge to include.
Well, as I said, I have no problem with the charges except for a certain language where it seems so doctrinaire about research has shown, or we're relying on this, you should look at it this way. I think that's what it's saying. I think the analysis is that in some areas it seems to undercut the juror's ability, or say to the juror, listen, you don't have the wherewithal to understand totally what we're doing here. I think a good approach is...
Isn't that true?
To some
most
extent.
jurors come in without any idea of what we're talking about here in terms of the fallibility of eyewitness testimony?
But that's why you have that amalgamation of people, that synergistic effect I spoke about, and basically the common sense rule. Jurors, the amalgamation of those people bring out a common sense that I think belies, the tricks or the different strategies that prosecutors may play or the police have played. I think they get identifications are visceral. Okay, they're cumulative. They're not decompartmentalized. And so when someone comes to court and they make an ID and they say they're confident in that ID, and we're saying that, listen, confidence alone, I agree that confidence alone is not the hallmark, but it seems to indicate that, you know, I think that could be worded in a different way so as not to say, oh, just because someone is confident or what have you, in terms of their being so positive, as it were.
Gene, let me just make sure that we cover one other thing before we're done, which is the race question. Our Supreme Court had already dealt with transracial identifications and the special problems, but revisited that issue in Henderson.
Right.
As a trial lawyer, in a practical sense, number one, do you find it true that there are greater difficulties in accurate IDs across racial lines? And secondly, are you comfortable raising that with the jury as part of your argument in defense of an accused?
Well, that's one of the issues that we have. Mr. Crumdy, whose case it was that established the New Jersey law, experienced that kind of discrimination in court, and the Supreme Court held that he was entitled to a special charge. And I think that it's important for the judge to be able to tell jurors that cross-racial identifications are problematic, because if I'm going to argue it,
right.
No jury wants to depend on my word for it.
So the charge makes you more comfortable dealing with it after the judge, or knowing that the judge is going to give the law.
Exactly. And for years, in terms of this kind of expert testimony, people like Dr. Penrod and other individuals who were cited by the Supreme Court in this case have been called in and have been called as witnesses, and have been, defense lawyers have attempted to call them as witnesses to educate jurors as to what the real issues in identification are, and not what their knee-jerk reaction
And is that expert
has.
testimony more likely to come in now?
The court says that their charge might substitute for the expert testimony.
Do you think it does?
For not necessarily. I think it depends. It's a case-by-case kind of thing. But I think the charge is very helpful because it comes with much more credibility for a jury than an expert does, who is put on by the lowly defense lawyer who is second on the totem pole in the courtroom.
On the scientific side, is there a quantifiable number that you can give us based on, you know, hard science experiments about how likely we are when we think we've seen something, when we think we've seen someone, to be correct?
Well, I can give you some numbers that I think approach that. There are good numbers out of the United Kingdom looking at the error rates among actual witnesses to crimes. In the UK, the breakdown is roughly, and this is across more than 15,000 witnesses, roughly 40% of witnesses pick the suspect, 20% pick a filler or foil out of the arrays, and 40% say not there. Now, we don't know whether the suspect is guilty or not, so we don't know whether those are correct identifications. We know that some portion are incorrect. We do know that all the filler identifications are wrong. And what those numbers indicate is that 1 out of 3 witnesses is clearly guessing, making an error by picking the suspect. So at the get-go, 1 out of 3 positive identifications is clearly problematic. Now, on top of that, if some people are guessing fillers, others have to be guessing the suspect. And that's where we get the DNA exonerations. That's where the innocent cases come from. So I think that's one way to begin thinking about accuracy rates. But we've also got some numbers even in cases involving people who are supposedly known to witnesses. There's an error rate somewhere between 6 and 9%, even in those cases, non-stranger cases. So there are problems. But there is a major difficulty saying that those are the numbers that apply in the courtroom. As we all know, more than 90% of cases disappear as a result of plea bargaining. And the mix of innocent and guilty at trial may be very different from the mix that goes into this system.
I don't want to pitch you against Anthony, but he made a very trenchant point. What percentage of ordinary people do you think have an understanding about how memory really works, as opposed to the false notion that it's a tape recorder?
Well, I think it depends on the phenomenon.
But as you walk across, come across people in your life, is it a high percentage or a low?
Well, I think it's a wrong question to ask, frankly.
But you have 20 seconds to tell them why.
The correct question to ask is, even if jurors know these things, are they taking them into account when they're evaluating eyewitness testimony? Or are they rolling
What's
over
your
in a
best guess,
sense?
yes or no?
They're not. They're paying attention to confidence.
And with our thanks to Steve Penrod, Anthony Guarino, and Jean Barrett, that is it for this edition of Due Process. But we'll be back next week and every week.
So we hope you'll join us for more cutting-edge issues of justice and public policy. For Sandy and associate producer Tanya Ivanova, I'm Raymond Brown. Thanks for watching.
Yeah, no, the system is imperfect. And I think one of the things we've learned over the last 20 years is how imperfect it is. I think I used to believe that the conviction of an innocent defendant was extremely rare, given the procedures that we have, proof beyond a reasonable doubt, and the defendant has a right to a lawyer, and the presumption of innocence. I thought, we almost never convict an innocent person, and now the DNA revolution tells us that my view was just wrong. We don't know how many innocent people we convict because we don't have a good methodology for computing that. But it's absolutely clear that it's not a rare event. It's an unfortunately all too common event.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.